Go ahead and turn it over to our next speaker. I don't think she needs an introduction. I think everybody knows Morgan Patterson. She's the KLC Director of Municipal Law, and she's going to talk to you about due process and conducting a hearing. So I'll turn it over to you, Morgan. Thanks.
Okay. Good afternoon, everybody. I hope you can hear me okay. I was muting myself earlier. So the poll, from the poll, it indicates that we do have mostly people who are involved in the Code Enforcement Board process. I know we do have one additional planning and zoning person, and then I know I've seen some city attorneys and city managers and administrators and the like on here. But today we're just going to talk about general due process for hearing officers, process, presentation for hearings, and general expectations. So the reason that you will see that this presentation is geared a little more towards code enforcement boards is that the statutes for code enforcement boards are a little more specific. They've been written later than most of the boards and commissions that we're going to talk about today, and include more information on processes, procedures, and even training required. So for those who may not have met me, I'm Morgan Patterson. I'm the Director of Municipal Law, and it's a pleasure to meet you virtually. Come say hi to me, please, anytime we're out and about. I know that we are excited, and I'm sure Cassie will Soraya will wrap us up at the end of this presentation, that in September, so far, our conference is going to be in person in Northern Kentucky. We're really looking forward to it. And next week, I even get to see some of our city clerks in Bowling Green. So it's an exciting time. All that being said, we will get to due process. So what we're really talking about with due process and procedures, as I mentioned, this applies primarily to code enforcement boards, but I think it can apply to any joint board or commission. Generally, a board or commission from a city perspective, it's going to be an administrative body established and empowered by the city ordinance to issue orders or to make a decision or to make a finding that's recommended to somebody later on. For code enforcement boards in particular, that statute authorizes those boards to hear any appeal from a decision of the code enforcement officer or other officer, depending upon your ordinance, of a city violation. So for example, tall grass is a real popular violation. So if a code enforcement officer, who may or may not be your fire chief, police chief, officer, city clerk, issues a citation, then they can appeal to the code enforcement board, who then would hear the appeal. The boards can be multi-jurisdictional, and this is similar for some other boards. Planning and zoning commissions can be regional as well, meaning that it could be a county and two cities, it could be city, what have you. Those are generally formed by interlocal agreement. And if anybody is interested in doing that, let me know. I can send you some samples. But we do have several boards and commissions that are multi-jurisdictional. Most of them involve county, some are city to city. The board must contain at least 3 members who are appointed by the executive, mayor, and a mayor council form of government, or the entire commission, if it's a commission form of government, or a city manager, and confirmed by the legislative body as a whole. So by the executive and legislative branches. For joint boards, appointments are established by interlocal agreement, but all participating governments must have representation. So 2 or more local governments can share an appointment, but they have to agree. And board members must live in the local government territory initially and throughout their term. And that's not necessarily the same for all board and commissions. Vacancies have to be filled within 60 days by executive appointment, subject to legislative approval, and joint appointments require an agreement of the executive authorities and approval of the individual legislative bodies. So even if you share an appointment, you're still going to have to get everybody on board with who's going to be appointed. And a member can be removed by the appointing authority. So on a joint board, that would be the appointing authority of the city that appointed that individual. right, by the executive for misconduct, inefficiency, or willful neglect of duty. So it's very similar to how any elected official is removed. So it requires misconduct, inefficiency, or willful neglect of duty. Okay. Other administrative boards that conduct hearings, and if I've missed one, please forgive me. But we have the Planning Commission, Board of Adjustments, Historic Properties Review Board, Ethics Commission, Vacant Property Review Boards, Parking Citation Enforcement Boards, and Economic Improvement Management District Boards. So the role of a hearing officer. With all of these different boards and commissions involved that can have hearings, code enforcement boards and planning and zoning have the authority to appoint hearing officers. The code enforcement boards can assign a hearing officer who can conduct hearings and make decisions in 3 different ways. They can do a recommended order. So if I'm a hearing officer, I can do a recommended order that goes to the code enforcement board for approval. Code enforcement board makes a final decision, and that can be appealed. A final order with appeal to the code enforcement board. So this sets up a multi-step process where I would issue a final decision. You could appeal my decision to the code enforcement board, and then the code enforcement board's decision would be appealable to district court. And then a final order with direct appeal to district court. I don't know of any cities that have these types of the last two, any of the structure where they do the final orders. And usually, from what I've seen, 99.9 times out of 100, the chairperson acts as a hearing officer. So planning commissions and boards of adjustment may also assign hearing officers. It can be a member of the commissioner board. The hearing officer or hearing examiner or officer issues recommended decisions only. And then the final decision is issued by the commission or the board with an appeal to the legislative body. And in these, when we're talking about final and recommended orders, so the difference between the two is that if I'm issuing a recommended order as a hearing officer, then the code enforcement board, or in this case, the planning commissioner board of adjustment, they can review everything. They do a de novo, it's called a de novo review, which just think of that as everything. So they can review all of the information, all of the facts that the hearing officer found, all of the conclusions of law and the like, and they can just chuck the hearing officer's decision and give it no weight whatsoever. If it's a final decision, then there's a different legal standard, and that's called substantial evidence of the record. And what that means is generally the decision itself is not going to be overturned, no aspect of the decision, unless the administrative body determines that there is substantial evidence in the record, so that they're saying, hey, you weighed the evidence wrong. It's 51% more likely than not that that this individual was untruthful, or that this fact was judged incorrectly. And then they have to articulate why they had to overturn that fact or decision. When, regardless of the process, when it gets to the board level, once it gets to court, they do a de novo review, generally. Now, with the planning commissions and board of adjustments, these go to the full city council or commission first, not board of adjustment, sorry. But planning commission, they're going to go to the full council in most instances. And then board of adjustments, those appeals go to court as well. But, and that is overturned only in specific instances too. So talk about who can be a hearing officer. So for code enforcement boards, it can be anyone. It can be any and all, including the chair. And as we said, with planning boards and commissions, it can also be those individuals, or it can be, for code enforcement, can also be a non-member. So if it's a non-member, that usually means that they've hired someone to come in to hear the facts and make the recommended decision or final decision, but they can't hold elected office or appointed office, and they cannot be an employee of the local government within the jurisdiction of the code enforcement board. So if you have a joint code enforcement board and you're appointing that individual member, or you're appointing a hearing officer for a hearing that impacts your city, then the hearing officer cannot be an employee of that city. Okay, convoluted, I know, but all fun. So hearing officer experience and training, and this again is specific to the Code Enforcement Board statute, but I think it would apply to any statute. You can check your local ordinance and find out if there are any additional requirements, because those can be imposed by statute. The hearing officer for a code enforcement board has to have experience or training in code enforcement and basic procedural due process. So if you're needing basic procedural due process, congratulations, welcome to my class. But the code enforcement process, it does say experience or training, and it doesn't indicate a set number of hours or what that training has to be. So it's really pretty open-ended. And it can be training provided by the city, provided by the board, provided by me. I've conducted this type of training before. But the basic procedural due process, there are certain elements in the statute which you're going to have after we've completed this course. So what is basic procedural due process? Okay, we're going back to the Constitution. You're going to have to reach far, far back into civics, civics lessons, some political science classes I had in college, and for me, constitutional law. But the Fifth Amendment of the U.S. Constitution states, nor shall any person be deprived of life, liberty, or property without due process of law. Pretty clear statement. And it applies to the states through the 14th Amendment of the U.S. Constitution. Nor shall any state deprive any person of life, liberty, or property without due process. So what is this mythical due process? What it means is when the government seeks to deprive a person of life, liberty, or property, procedural due process requires that the government take minimal steps, very, very small steps. Notice, an opportunity to be heard, and an opportunity to confront witnesses. And that's essentially the procedural due process we're talking about. These are not law and order cases. And you'll hear me say that a lot. If you watch any of these court procedurals, Law and Order, or that's the only one I can think of off the top of my head, but you're gonna hear that this is a much abbreviated version of what a normal court proceeding would look like. And if you've ever sat in court proceedings, you'll know that hearings are a lot different. So what it does not mean, it does not mean that you guys have to have, the Code Enforcement Board or the Planning and Zoning Commission or the Board of Adjustments. You don't have to come out in a long black robe, carrying a gavel, or wearing a powdered wig like they still do in Great Britain. It doesn't mean that you have to be super formal. Hearings are not going to be subjected to that level of formality and precision, nor are the rules that restrictive. Okay, it's not a criminal proceeding. There are other due process procedures that you hear that aren't procedural, that are not going to come into play. The right to a speedy trial, the right against self-incrimination, the right to a grand jury. None of that applies, right? This is a whole different situation. We're talking about an administrative proceeding. Okay, so the basic due process for Code Enforcement Board is established in the statutes, right? And what it does is it gives the particular timelines for each individual issuance, response, and decision. So we have the citation. The Code Enforcement Board, a code enforcement officer is going to either issue a citation, or they can do a notice of citation if your ordinance authorizes it. A notice is just sort of, like those yellow warning stickers that you get when you've been speeding. Not that I've ever gotten one of those, but I've seen them. So that's what it's like. It's like, here's a notice of a citation. So if you don't fix this, then next I'm coming and giving you an actual citation. But if a citation is issued, it has to be issued to the person. Okay? This means that it can be sent by US mail. It can be sent by registered mail, handed to the individual who is on premises, or posted. And a lot of times when there are vacant properties or properties where somebody doesn't want to receive their citation or their notice, what our recommendation is to both post it on the property and send it by first class mail. What that does is that gives the code enforcement officer a clear record. So you post it on a tree on the property or tape it to the door and you take a picture, then you get a time and a date stamp. Hey, this citation was issued on this date on the property. Even though we sent it by US mail, we know that at least the property was posted on this date. Okay. It explains the violation, gives them notice of what the violation is and the penalty. Some city ordinances are going to have an explicit penalty. This is your first offense for, grass that exceeds the city standards over 10 inches. So it's $25 fine. Right. Second offense, 50. Some may have bans, it may be between 50 and 100 or what have you. The notice of the hearing. So after the citation is also going to say you can either pay this citation or you can appeal it. You have to, if you appeal it, you have to file an appeal within 7 days, and it's going to give the information where the appeal can be filed. Right. So the notice of hearing, the 7-day notice, it's going to explain where and when, and I'm laughing at myself for the way I've abbreviated this, and I think I do it to fit it on the slide. So the citation can be appealed within 7 days. The notice of the hearing is then provided to the individual. It's a 7-day notice. It has to say where and when the hearing is going to be, is going to occur. And the delivery follows the same process as the delivery for the citation. It can be by first class mail, registered receipt. And the reason, anyone who's done these before, the reason it's very rare that anyone selects registered mail return receipt is that if somebody doesn't want to be served, they're never going to come pick that sucker up. So generally, first class mail and posting or in-person delivery is what you're going to see. So once the hearing is conducted, then there's a notice of final order that goes to the individual, and that's going to include findings of fact, conclusions of law, and a decision. And that decision will be, we uphold this citation and you must pay $50, or we've upheld the citation but we've reduced the penalty to this, or you have additional time to fix it. There are a lot of different routes it can take, and it has to have the date issued and then delivery, or delivery by the same means. Sorry. Basic procedural due process for parking citation enforcement boards. And this is another one. The citation is provided on the vehicle. It includes violation and the penalty, and they can appeal within 7 days. The notice of hearing, the individual has to receive a 14-day notice where and when it's going to occur, and delivery is by the same means, by US mail, US registered mail, return receipt, and then the final order. Final order is also a written decision. It's issued at the hearing in those cases, and then the individual can appeal within 7 days to district court. Okay, so the Planning Commission for map amendments. For this one, the public hearing is going to be posted within 14 days. Adjoining owners must receive notice delivered by first class mail 14 days in advance, okay, of the hearing. The notice of hearing, the notice will include a statement of the zoning change, the proposed classification it's changing to, and the time, place, and date of the hearing. Ultimately, after the hearing, the Planning Commission is going to do a proposed classification, whether it's appropriate or not, a determination of whether the major changes substantially alter the area, and then they're going to give that order ultimately to the parties of interest and to the legislative body. Basic procedural due process for boards of adjustments. A notice will be issued to the person, right, by US mail or by hand. It'll explain the action. What's the action to be taken? What's the violation, or what is the, what's the zone violation, right? They'll have 30 days to appeal. It's usually given by the zone administrator or the zone administrator's, the person working for the zone administrator who issues the actual tickets or citations. There's a notice of hearing. It has to be within a reasonable time. So there's not a specific, the notice has to come within a reasonable time. There's not a specific deadline in the statute. It's given to the public and to the appellant, right? So and for the public, I think it's not less than 7 days prior to the hearing, nor more than 21 days prior, but at least 1 week prior to the hearing. Right. Notice of a final order, findings of fact, conclusions of law, and they have to receive it 60 days after the hearing. And delivery is by first class mail. Okay. Basic procedural due process for historic properties and architectural review commissions. This is generally initiated by an application, someone applying to change something on a historic property, or change the architectural status in an architectural area. It's a decision to issue a certificate of appropriateness for whatever plans they're proposing, or it can also be the designation process for local landmarks and districts. The notice of hearing has to be published according to KRS 424, which is no less than 7 days or more than 21 days prior to the hearing. And the individual has 30 days from the decision to appeal, right? The decision and recommendation itself is established by local ordinance. So any timing or information that's required by the board itself, that's going to be established by local ordinance. All right. I don't see any questions. So either it's after lunch and you guys are sleeping, which is fine. I'd like to nap after lunch, or I'm explaining it so well, right? Okay, basic procedural due process. So we've gone through the basic timelines. Now let's get back to our subject matter here. How much process is due? Now we know we've given everybody their notices. We've provided them all of their citations, their notices of appeal, blah, blah, blah. And now we're going into a hearing. So what do? Due process is judged by the scales, right? The scales of justice. It's going to balance the risk of depriving a person of their private interest, okay, versus the administrative burdens on the government caused by providing a heightened level of due process. This is why when I talk about differences between the due process required in an administrative hearing, like a board or commission, it's different from that you see in criminal court, because the risk of deprivation for me is to pay a fine, okay? Whereas the risk of deprivation to an individual in the criminal justice system is their complete loss of liberty, which is definitely a higher interest. So, specific due process procedural duties, these are assigned to the hearing officer. And when I say hearing officer, in any board or commission, your chairperson may act as the hearing officer if you don't appoint a specific hearing officer that hears the appeal outside of the presence of the board or commission. So that individual, we'll call them the hearing officer as well, just to give you context. So that individual will be tasked with administering oaths to witnesses prior to testimony. And don't get too excited. The oaths are very simple. There's no specific oath in statute, but the basic one that I have in here is the one I used when I was a hearing officer for the Cabinet for Health and Family Services. And it's just, do you swear or affirm evidence you are about to give will be the truth, the whole truth, and nothing but the truth. You can add to it or subtract from it as you see fit. Subpoena alleged violators, witnesses, and evidence if the Board or Commission has subpoena power. And subpoenas can be served by any code enforcement officer if it's a code enforcement board. Code enforcement boards are statutorily given subpoena power. Make any written findings of fact and conclusions of law as part of the written recommended or final order. So based on the evidence, did the violation occur? The findings of fact and conclusions of law really terrify people because it sounds super fancy. But what you're really doing as a member of a board or commission is determining, hey, based upon what I'm seeing here, is it 51% more likely than not that a violation occurred? Or is it 51% more likely than not that these standards are within our jurisdiction to provide? Or is this, is this request for a certificate going to completely, is it going to run completely contrary to the historic significance of the area in which they want to, build this house? Is the mother-in-law's quarters going to completely destroy the historic character of this property? That kind of thing. So it doesn't have to be terrifying or super fancy. And generally, we do recommend that if it's a super contentious issue, or if it's something that make it pretty technical, that the code enforcement board or any board retain separate counsel, because usually in these instances, the city attorney is going to be presenting the case on behalf of the city. That may or may not be true with all boards. The Historic Properties Board might have its own lawyer or may seek assistance from the city attorney. Board of Adjustments may have their own attorney. The Planning and Zoning Commission probably either has their own attorney or has someone they can contract with. It's really going to depend upon the comfort level of the individual city attorney, whether they believe that it would be a conflict of interest for them to proceed. But regardless, the findings of fact and conclusions of law are something that you don't have to be afraid of. Okay, as I said, KRS 65-8829. Actually, I don't think I said the statute, but the statute is part of the Code Enforcement Board statute, and it talks about what hearing officers have to know. And these are the basic due process procedures that hearing officers are required to understand. I think these are important for any administrative board to have down basically, right? The basic level procedural due process. And this is that somebody has the right to be accompanied and advised by counsel at the hearing. So they have the right to bring their own counsel. This is not the same thing as a right in Bill of Rights to have counsel appointed to them, right? They can bring their own counsel and to be accompanied by counsel, but not have a counsel appointed. They have the right to present evidence and witnesses on their behalf at the hearing, to examine evidence from the opposing party. So anything that's presented against them, they have a right to look at it, to confront and cross-examine witnesses the opposing party presents. So they can examine the code enforcement officer or the planning and zoning administrator. They have the right to cross-examine them. Okay, so what is the right to counsel, the right to be accompanied and advised by counsel at the hearing mean? It means that both the alleged violator and the city can have legal counsel. The city attorney can be counsel for the hearing board or counsel for the city, not both necessarily, because it's going to be very difficult in that situation for the city attorney to advise the board and in making decisions and rulings on objectives, on objections and that type of situation when they're actually presenting the case as a prosecutor, right? So that's not mandatory. The attorney can be present and examine witnesses and evidence on the alleged violator's behalf. And the attorney can speak on the alleged violator's behalf, except when the person's giving testimony. And I can tell you, I didn't come across this a lot when I was a hearing officer, but occasionally it would happen where an attorney came to represent an indigent client and they would try to testify for the individual. As a hearing officer or, chairperson of the board, you can nip that in the butt pretty quickly. It's not required that they be allowed to do that. So the right to present evidence and witnesses. Evidence includes photographs, videos, documents, or any other physical proof of any kind, receipts that something's been fixed, you know, property plans, blueprints, that kind of thing. The witnesses include neighbors, household residents, police officers, or other city staff, professional inspectors, or experts. As a hearing officer, you can set limits on the time of presentation and the relevancy of what's presented. But I will encourage everyone who's in this situation, prepare to be flexible, particularly if someone comes before the Board of Commission and they're not represented by counsel. I had one attorney when I was a hearing officer tell me that they always knew when they were winning a case because suddenly I let the other side just enter anything in and provide any type of information. Okay, so the reason I did that is because as a hearing officer, I would much rather have had the hearing go on a little longer than have someone have a built-in argument on appeal that they hadn't been allowed to present their case. This doesn't mean you have to go, you know, insanely far. Now, I do have one question. So Amberly Martin asked, just to clarify, you're saying that if a violator brings legal counsel, we as a code enforcement board have the right to request that the violator provide the testimony and not allow the legal representative to do so. So the question here is going to be, you don't have the right to force an individual to testify. And this might be seem like a distinction without a difference. If the individual is going to testify, and if they're going to provide evidence, then if they're sitting up there or sitting in the assigned witness chair as the witness, the legal representative can't testify for them, can't put words in their mouth, that kind of thing. They have to be allowed to testify themselves. However, their legal representative can bring in and can present their arguments in the case. And a lot of times in a more informal board setting, that's going to look a lot like testifying. So the issue is that individual, have they been sworn in? Have they been seated as the person to testify? Or is their legal representative simply going to carry the ball and provide all the information? But that was a really good question. Okay, so you can set limits on the time for presentation, as I said, but prepare for flexibility. And then the general test for relevancy. And this is something that we'll discuss a little bit more. You know, a lot of people would like to muddy the waters and bring in, you know, a note from their second grade teacher that they were a really good person. That may not be relevant to whether they cut their grass, okay? So the general test for relevancy is whether the evidence tends to prove or disprove a material fact, issue, or a fact material to the issues before the board. So if it's cut grass, like I said, or even a note from their second grade teacher says they always cut my grass and did a great job, that's not going to be relevant as to whether they cut their grass 2 weeks ago and whether it's over 10-inch limit. Okay. And then I had another question. What about perjury? Perjury isn't something that I would necessarily pursue in an administrative board. These, you know, even though they're going to swear or affirm, unless it were something significantly egregious that fell under another state law, courts are not likely to enforce that from an administrative setting. Okay, so perjury, if it rose to the level of illegal slander or libel, then that would be something that someone, the person who are the subject of the slander or libel, that they would be able to pursue individually. But perjury in and of itself, that's not something that's pursued in an administrative setting. But that's a good question. Okay, the right to examine evidence and cross-examine the witness's opposing party. So again, evidence, photographs, video, documents, or physical proof. So in a code enforcement board hearing, that's going to be pictures probably of the building itself, or even statements from people or complaining witnesses. For others, it can also be photographs, blueprints, copies, parking citation board, It can be a picture of the car, time and date stamp, that kind of thing. Witnesses, they can cross-examine neighbors, household residents, same here. You can set limits on the time and the relevancy again. So in that instance, I was always careful about ensuring decorum, even if a pro se litigant is going to go ahead and cross-examine a witness. It's very important that decorum be maintained because hearings can get away from you quickly. And we'll talk a little bit more about that. So now on to subpoenas. Subpoenas are official documents that mean someone has to show up or face legal consequences. The chairs of the hearing board for code enforcement board, they can definitely sign subpoenas, okay? And there are other instances, very limited instances, where code enforcement boards may be able, or where other boards and commissions may be able to utilize subpoenas, okay? But it has to be given or given by case law or by statute. So a lot of boards and commissions are not going to have the authority to subpoena. Subpoenas can be for people, documents, or any other kind of evidence. And if possible, allow some people reasonable notice. You know, when I worked for state police, they used to love to subpoena people for court, you know, in 3 days, in 4 days. Well, that's not necessarily reasonable. And even though there's not a stated deadline in administrative subpoenas, you're going to want to give people notice, or an unreasonably short amount of time could cause grounds for appeal. Subpoenas that are ignored in the code enforcement board setting can be enforced in district court. So this is basically what an administrative subpoena looks like. It gives me chills just to look at it because I used to send out tons of these as a hearing officer. Okay, so do we have any other questions? I don't see anything popping up anywhere because we're going to move into the nuts and bolts of conducting a hearing. All right, we'll rock and roll. As I've stated multitude of times, which if I do that, it usually means it's important. Administrative hearings are not formal. I can tell you I have conducted administrative hearings all over the Commonwealth of Kentucky, carrying a little briefcase in rooms that held about 3 people in tiny little cities all over. Okay, whether they were certificate of need cases in Frankfurt or Medicaid appeals in Morganfield, been everywhere. So it can be conducted it doesn't have to be conducted in the court. In fact, most of them, I don't know of any that have been. There probably are some. It can be conducted in a city building, office, or a room, the size of a broom closet. I've done that. A recorded audio or video. I carried around this tape recorder. I'm pretty sure was manufactured in 1920, but it continued to work, and I carried around my little tapes. Audio or video. Nowadays, you can get a digital recorder that's about yay big for $50. So that would be my recommendation if you don't have the infrastructure for a full hearing room. Copies of evidence, if at all possible, choose a facility with a copier, right? Because a lot of times if a pro se litigant comes in, or if someone, pro se means they're not represented by counsel. I realize that I've been using that buzzword throughout this presentation, and I'm just now telling you what that means. The pro se individual is someone who doesn't have counsel. So it means by themselves, on my own, okay? So if an individual comes without counsel, an unrepresented person, and they show up with copies, they're gonna have originals. They're not gonna show up with copies that have exhibit markings on them or what have you. They're gonna show up with probably a stack of paper about this tall that looks like something I scraped out of my back seat. And then you're going to have to have copies for the record. So try to choose a facility with a copy machine, right? And tell the parties what to expect at the beginning of the hearing. I would always introduce myself and say, hey, here's the process. Don't be nervous as much as you can. This is an informal hearing. Here's how it's going to work. And explain the full process, including how long until a decision will be issued and what the next steps will be. So the basic phases of an administrative hearing look very similar to a court of law. You have an opening, receiving testimony and evidence, and then you have a closing. Simple, very simple. The first part of an administrative hearing for me when I was a hearing officer, it was really my opportunity to lay the groundwork for how the hearing will proceed. I would establish expectations ahead of time. I am not an intimidating female. I'm not very big. I'm taller than average, but I'm just not an intimidating person. So it always makes sure that my expectations for both parties were clear. I expected decorum, no name calling, and I just wanted people to be polite to one another, right? I talked about not interrupting each other, and I went through a very specific process to lay out my expectations and the ground rules. You know, it's important to lay out those ground rules. If it's being recorded only by audio, you know, saying, don't say or or shake your head, we're not gonna pick it up, say yes or no, that kind of thing. That's good for audio and video as well. If the alleged violator is not represented, this process can require a lot of time. And I would recommend giving them the opportunity to ask questions if they're not sure how the process is going to move forward. Regardless, it is important to maintain control of the flow of the hearing from the get-go. And I've found that having that prior to the parties even getting into it, having the conversation, you know, laying out the groundwork was always really helpful. Unrepresented parties, they might try to attack citations, evidence, or what have you, immediately upon having the opportunity to speak. And it's okay to cut people off and tell them they have to wait their turn. It's not always comfortable, but it's okay. So let's begin. I always started the recording, gave the date and time. If there's a case number, I would, you know, state the case number. You know, we're here today in the matter of Elizabethtown versus Smith. Provide the citation number or case number if it's planning commission or other type of commission. Explain, kind of summarize the hearing itself. Why are you there? What's the purpose? The code enforcement officer accuses Smith of violating the nuisance ordinance, okay, as indicated on the citation. Explain the alleged violation and how, if it's true, how's that going to impact the individual? So even like historic properties or architectural review board, they've requested this, you know, this certificate. If it's granted, then this property is going to exist. This mother-in-law's quarters, whatever you want to call it. This property is going to exist. This secondary, you know, secondary housing. If it's not granted, then you cannot build this, and you know, these are the consequences of that action. Ask the alleged violator or the person presenting a petition or appellant, what have you, ask them if they're represented by counsel. Okay, then explain the rules of hearing. Set the guidelines in hearing. Tell them to say yes or no. Like I said, don't shake their head or Advise all present to show decorum. No talking over one another. You can't get a clear record. And you can set a time limit on testimony. So if you set it, you're going to have to enforce it. But each party needs to be given as much time as possible to explain their position. If there are witnesses, ask each party whether they want to separate them. If you're going to have witnesses in the hearing, it's really up to them whether those witnesses can listen prior to them testifying. Some people feel like that could negatively impact the witness's testimony if they have an idea of what's been said before them. Separation of witnesses is, from my perspective, when I was a hearing officer, it was usually the norm. Okay, explain that the city bears the burden of proof in most hearings. The city, in code enforcement board hearings, the city bears the burden of proving the violation by the preponderance of the evidence. 51% more likely than not that the violation occurred. Same for parking citation boards. In some instances, it's going to be the individual filing the petition who bears the burden of showing that it's within the variance. What am I trying to think of? How am I trying to explain it? Kind of in the realm of variances that the board can approve. I had a great word. It's on the tip of my tongue. Can't think of it. I don't know if anybody on here ever has that feeling, but I do. Or that the certificate that they're asking for is outside of the standards of compliance for the Architectural Review Board or the historic property. Okay, start the hearing. Explain that the city goes first because they have to prove their case. Okay. The alleged violator can then present their case and each side gets a turn to counter. If the alleged violator is not represented by counsel, the hearing officer can ask them questions. The hearing officer can ask questions anyway. As I said, it's informal. The board itself may have questions that will help it understand or come to a resolution. In this context, it's not uncommon at all for the board to ask clarifying questions. My suggestion would be for each board member to submit them through the chair, just because that helps with the continuity of the hearing. That may not be the case for you. It's all personal preference. Ask each side if they would like to make an opening statement. Explain, if asked, what it is. That's simply an explanation of the party's position, explaining why they're there. If the alleged violator has requested an opening statement, they give one first and then the city's next, right? And you can also set time limits on the opening statements and the closing statements. There's nothing wrong with that. And if you have someone who's unrepresented by counsel, that may be in your best interest to do so. All right, receiving testimony. Each witness is sworn in by the hearing officer, chairperson. And again, I put the oath that I used here, totally up to y'all, what you use. And then testimony has several parts: an examination, a cross-examination, rebuttal, surrebuttal. So the examination is just that the party presenting the witness. So if I'm the pro se individual, unrepresented person, I'm going to get up there and I'm just going to tell my story, right? I'm going to give you all my evidence. Then the other person, the city, has an opportunity to cross-examine me and they can ask questions. Cross-examine doesn't mean that you're rude and combative. That can be controlled by the hearing officer. It does mean that you can ask questions, and sometimes that does get combative, but it's important to keep a lid on that as much as possible. Then the party presenting the witness can do rebuttal and the opposing party can do surrebuttal if you get there. Receiving evidence. Each side is allowed to present evidence to prove their position. The city will provide the citation generally as the first exhibit in a code enforcement board hearing or parking citation board. Not a big deal. It's a matter of taste whether to label the exhibits numerically or alphabetically. Some people like to do like two different exhibits for the two different sides. So you'll have the plaintiff's exhibits 1 through 20, the defendant's exhibits 1 through 20. I always numbered them just one at a time. They were just the hearing exhibits. I didn't lump them all in together. The alleged violator can provide receipts to show that work was done, that they fixed it, or other evidence. In other types of hearings, as I mentioned, they'll provide blueprints, they'll provide maybe historical documents describing the architectural nature or the historic nature of the area to show that what they propose is acceptable. Same thing with zoning. They may provide information that what they're doing isn't going to change the essential character of a zone, or that the zone has changed substantially and it should be rezoned to X, Y, or Z, and that's within the comprehensive plan. And now we're going to talk about relevancy. Relevancy. It's a simple word and it can be a sticky wicket. But what I can tell you is, as a hearing officer, it was something that was very important for me to stick to. My hearings, each individual hearing I had could have lasted 5 days, I can tell you. If people were given an opportunity to say everything they wanted to say, it could have drug on forever. So only relevant testimony and evidence can be considered by the hearing officer or the board or commission in making a decision as to whether a violation occurred or any other decision we've discussed. Relevant testimony and evidence content is that which proves or disproves the fact at issue. Okay, so it proves or disproves violation occurred, proves or disproves that that the proposed structure or proposed amendment to the property is consistent with the historic area, proves or disproves that what they're proposing is consistent with the zone they're in, or that a violation occurred. Okay, so the citation is relevant as well as an application and any other evidence that's provided that tends to prove or disprove the fact. A note from Mama saying that she really didn't do it, probably not very much. And I will tell you, I say that in jest, just kind of tongue in cheek, but you'd be surprised how many people would kitchen sink a hearing. And by that, I mean, throw everything in but the kitchen sink and just try to drag in every possible piece of evidence that in their mind shows that they're a good person and they really, really needed whatever Medicaid, Medicare, whatever hearing I was conducting, or that their ambulance service was really awesome and they should provide service to an overly saturated area, that type of thing. The reality is the only thing that's relevant is what the hearing officer determines, and that's ultimately whether it proves or disproves a fact necessary to make a decision. Right? That's where a lot of boards will find attorneys useful. I know we get a bad name. I used to get it all the time at State Police. We hate attorneys, but you're our attorney. Yeah, that's quite the compliment. So, as for the closing statement, and this is just a slide I really like because I drink coffee constantly. Closing statements. In the closing statements, I generally, as a hearing officer, I explain the final process. I would explain how long it would take for me to make a decision, and how long it's going to take me as I anticipate it, or if your statute or your city ordinance gives you a deadline, know that deadline and let everybody know in the hearing. Is it a final order or recommended decision? You can say that in the hearing as well, and tell them, notify them of appeal rights. Like, you'll have my decision in this number of days. You're going to have 30 days to appeal it to district court, which is the majority of the boards. Okay. Or once the planning commission has made its recommendation, it's going to go to the legislative body, that kind of thing. Closing statements, as I stated, each party can provide closing statements. If you have unrepresented parties, once again, I can't say this enough, I would limit the time that they have for closing statements. And, and just give everybody an opportunity to wrap up and to summarize what they have to say. All right. Now, y'all, I'm open to questions. You can unmute yourself and ask. You can, I didn't even ask if you could. I think you can. You can type in the question and answer or in the chat. I will respond to you. So I really appreciate y'all's time today. And I'm here anytime you need anything.
Also, if anyone would like to ask a question aloud and has a microphone, they can use the raise hand feature and I can unmute them.
I knew there was some kind of trick here. Can we get a copy? No, Tony, cannot have a copy, not ever. I believe you can. Yes. Are we going to send them copies of the PowerPoint?
Yes, ma'am. We will be sending a follow-up with the PowerPoint this afternoon.
We had a good question. You know what? This is something that I need to cover. We have a good question from Amberly Martin. Excuse me. As far as the final decision, do we have the opportunity to discuss as a code enforcement board without the violator presence if our ordinances allow for time? Here's why that's a great question, because that answer is yes to almost everything that planning and zoning. So if you are an administrative board other than planning and zoning, the Open Meetings Act allows a quasi judicial body. And yeah, I know you don't think of yourselves necessarily as quasi judicial, but you are, because you're sitting in the capacity to make a determination on behalf of the city, right? So you're a quasi judicial body. The quasi judicial body can go into closed session and you can go into closed session to discuss the decision. That's a limited exception under the Open Meetings Act, which y'all are all covered by, and planning and zoning is not included in that, just to emphasize again. So you absolutely can. Any decisions have to be made in an open meeting. So you can go in and you can discuss your decision, you can discuss your decision-making process, but you either, your statute says you have to give it your final decision in open session, then you do it, or you can wait and issue your final decision in writing and your findings, fact, and conclusions of law. Any other questions?
We do have a
Well,
hand raised from Dalton Miller. I will go ahead and allow
Yeah.
her to talk.
Morgan, the question is, if we record these hearings, how long do we maintain those? Because they would be evidence if it was appealed to a district court.
Mayor, that is a good question. So you would have to retain those hearings for however long it's stated in the Department for Libraries and Archives records. And what I do not know that off the top of my head, but I can send that to you. For anybody who's not familiar, the Kentucky Department for Libraries and Archives establishes our records retention. And I don't know what it is for recordings of quasi-judicial government bodies. We had a question. Mayor, did you have a follow-up to that, or was that good?
No, that's good. Thank you.
Good to hear you, sir.
Thank you.
I have another written question from Ms. Moore. So you have not made a decision at the meeting. Do you have to have another open meeting to receive the decision? This is going to depend upon what your ordinance and statute says. So, for example, where were we? You may have an ordinance that requires you to provide the decision at the hearing. And I know that I know this is horrible, y'all. I can't remember all these boards and commission requirements off the top of my head. So, for example, the Parking Citation Enforcement Board, they have to make their decision at the hearing. But I don't think most boards and commissions are required to issue theirs at the hearing. That doesn't mean that you have to receive the decision in that meeting, but it's usually you're going to have to make your decision either, in your meeting, or somehow have everybody sign off on the decision, or the findings of fact and conclusions of law may be written ahead of time, and then maybe at the next meeting you can approve them, depending upon how much time you have to make that decision. Everybody who participates from the board, every vote, what have you, they're going to have to sign that, or the code enforcement board chair can sign, and people can sign virtually. We do have that exception, for example, in Senate Bill 150. And even if you sign somewhere else and fax it or mail it, generally that's going to be authorized. So the answer is, if you've already made the decision and you have an agreement, it doesn't necessarily have to be an open session, depending upon the statute and depending upon your city ordinance. Is that helpful? Okay. Any other questions?
Morgan, it looks like we're getting to 3 o'clock, so I think that we are good for today. If anyone has any questions and wants to respond to our follow-up email, I can get those forwarded to Morgan, and we'll include her contact information in that email as well.
And the PowerPoint will be in that too, Sarah?
Yes, it will.
Awesome. Thank you everybody for your time, and thank you to our training department for taking care of me as always. I appreciate everything y'all do for us, and hopefully I will see everybody in person soon. Bye y'all.